Welcome back to Winning Isn't Easy. Kate, as you close out your career, what are your words of wisdom that you would give to disability policyholders and plan beneficiaries who are starting the claims process, going through the appeals process, and then ultimately potentially dealing with litigation?
Well, we kind of covered a lot of them, to be honest. I think the most important thing is to read your plan, to read the denial letter, to get an attorney, and to be timely. We haven't actually talked about timeliness, but it means a lot in ERISA. There are very specific deadlines for everything, and to get those meet those time deadlines. More broadly, sort of thinking about the whole process, I think it's important to understand that disability benefits in ERISA in particular are not a given. Many folks came into my office thinking, well, my gosh, I paid a premium for this the whole time I've worked for this company for 40 years. What the heck is going on here? And it's always important to understand that disability benefits for people who are unable to work because of a medical condition. And it's a combination of both the medical situation and the occupational situation that are what determines whether you're disabled or not. And it's not a given that you're going to get disability benefits just because you have them or are entitled to them through a policy with your employer. The entitlement is to have the coverage. The entitlement is not to have the benefits. To get the benefits, you have to establish all the elements under your policy and basically that you're disabled and your occupation, you can't perform your occupation.
I have known Kate for many, many years. She's been a wise woman on the mountain of the world of ERISA attorneys, and there aren't quite frankly, many of us ERISA disability attorneys. And so what words of wisdom do you have for us ERISA disability attorneys in being more effective communicators and litigators and just client advocates you would like to pass on?
Well, I think we need to be advocates for sure, and maybe not just for our clients. It behooves lawyers in this very niche area of practice to get involved in some of the regulating that goes on, like the Department of Labor, and have a voice in how regulations that govern ERISA get adopted. I've participated in some of that over the course of my career, and it's made a difference for many of my clients. Get involved in your state legislative process. It's a very complicated argument, but there are some state laws that aren't governed by ERISA, but that implicate ERISA, and get to hold of your state legislators if that's a problem in your state. For example, many states have banned discretionary clauses in policies, and that's the work of ERISA attorneys and claimants getting out there to their state legislators and getting that changed. I think it's necessary because it is such a niche area of practice. If we don't speak up on behalf of our clients in the overall world to the legislatures and the Congress, it's going to stay a very dark secret about how difficult it is to get benefits. It shouldn't be as difficult as it is, but by the same token, it has to be a somewhat adversary process in order to make sure that benefits are available to everyone that needs them.
You know, as we've alluded, it really isn't any class that you take in law school on ERISA litigation, and federal judges hear all sorts of cases, from civil rights to criminal to drug to all sorts of other issues. And one of the things that we've tried to do, at least in the 11th Circuit, to educate judges about ERISA is to have what we call bench and bar conferences, where we invite the defense and we invite attorneys such as ourselves. We invite the judges, and we kind of try to use that as a way to kind of educate judges. So I absolutely agree with you that we need to be trying to influence the legislative process, the insurance regulation process, and to the extent to which we can educate the judges, also do that. In closing, are there, reflecting on your successful career, the influence that you've had not only on clients, but lawyers like myself, who are going to terribly miss you. Any final thoughts?
I'm going to miss you too. And I don't mean just you. I'm going to miss the ERISA lawyers. Because we are a small group, we get to know each other because we don't have a whole lot of other people to
hang out
turn
with.
to.
Yeah, other than the defense attorneys.
And I will miss that tremendously. And I'll miss my clients very much. Some of them have become dear friends, and it's an important job that somebody has to stand up for these folks, because if there isn't anyone to advocate for them, a grave injustice is going to be done. And I wish I could stay in the groove, but time and tide waits for no man or woman.
Right.
And unless I must bring myself into a new vision of myself. I'm not quite sure what that's going to be yet, but believe me, I'm doing my research.
Well, I know that you will be successful and will make a difference in people's lives. So please keep it up, and please stay in touch. And thank you for joining us for this week's episode of Winning Isn't Easy. If you've liked this episode, please give us a shout out. Please like the episode, refer other people to this episode or other episodes, and please subscribe to the podcast. So thank you, Kate, and the best to you and your family.
Thank you. It has been my pleasure.